Hey there guys, it's Mel Monty. It's been a little while since I've uploaded a video, but I wanted to share some news coming out of New York, which is really interesting. New York has been pretty active lately. I talked a few weeks ago about New York banning the use of the term illegal alien in certain circumstances, but there are a couple of other articles coming out of New York. So this one from NBC News, New York governor blocks some federal judges from officiating at weddings. Why? Because they might be Trump nominees. New York Governor Andrew Cuomo has vetoed a non-controversial bipartisan bill that would have allowed all federal judges to officiate weddings in the state because some might have been nominated to the bench by President Donald Trump. I cannot in good conscience support legislation that would authorize such actions by federal judges who are appointed by this federal administration, Cuomo's veto message stated, the New York Post reported. President Trump does not embody who we are as New Yorkers, the Democratic governor added on Friday. The cornerstones that built our great state are diversity, tolerance, and inclusion. Based on these reasons, I must veto this bill. The legislation, sponsored by Democratic State Senator Liz Krueger, passed the state Senate by a 61-1 vote. It passed the state Assembly by a 144-2 tally. Both the state Senate and Assembly are under Democratic control. Currently, New York law permits all state judges in their official capacity to preside over wedding ceremonies, although only certain federal judges, like those in the Second Circuit Court of Appeals and those at each of the state's federal district courts, are eligible to preside over weddings. This bill would have expanded the wedding authority to all federal judges, largely those from outside of New York. Trump has now had nearly 100 federal judges confirmed through his first term, including one in every four circuit court judges. Okay, so there's that. I do wonder how, considering it's a Democratic-held Senate or Congress there, and it was passed so overwhelmingly, I do wonder kind of what the Democrats were thinking there and how they responded. I might have to follow up on that a little bit. All right, so the next one is from Breitbart News. And this one says, New York to allow accused criminals to inspect own crime scenes. Quickly obtain witness names. Okay, so whatever could this mean? The state of New York will soon allow accused criminals to inspect their own crime scenes and will quickly provide them with a complete list of named witnesses testifying against them as part of a series of new jailbreak laws. As Breitbart News reported, New York's bail reforms, set to go into effect in January 2020, will ensure that suspects accused of crimes deemed nonviolent are not jailed before their trial date and do not have to post bail. Instead, these suspects are released directly back into the public and expected to show up for their court dates. Roughly 125,000 accused criminals are expected to be released from prison every year in the state. All right, so getting down here, it says, these so-called nonviolent crimes include second-degree manslaughter, aggravated vehicular assault, promoting an obscene sexual performance by a child, possessing an obscene sexual performance by a child, criminally negligent homicide, and aggravated vehicular homicide. As part of the measure, defendants will have new privileges in their criminal trials, including being allowed to inspect their own crime scenes. So, for example, if an individual is charged with home burglary, the suspect will be allowed to return to the victim's home and inspect their property as part of their defense. It really boggles the mind that this is the reality for us now. Lieutenant Stephen Stockdale of the Warren County Sheriff's Office told CBS 6 Albany in October of the provision. Talk about re-victimization. Another portion of the law will more quickly give defendants a full list of named witnesses testifying against them in the criminal trial. Starting in January, the prosecution will be forced to hand over to defendants a list of named witnesses within 15 days of the defendant's arraignment. In June, the Manhattan Institute's Seth Barron and Ralph Manguel wrote that such a provision will make it impossible for prosecutors to ensure witnesses are protected through the criminal trial process. So, prosecutors will no longer be able to assure witnesses that their identity will be protected, even in the case of grand jury testimony, which the new law will now require to be disclosed. While there's a provision to ask a judge for a protective order to shield a name, that would come after cops and prosecutors talk to witnesses to make an arrest and build a case. Okay, the Manhattan DA put it this way: having to hand defendants a roster of who has spoken out against them just 15 days after their first appearance, absent a protective order, is a seismic change that undoubtedly will dissuade witnesses who live in all neighborhoods from reporting crime. Okay, so they do talk a little bit about federally. The First Step Act that was signed into law by President Trump has thus far freed about 240 sex offenders, nearly 60 convicted murderers and assailants, as well as almost 1,000 inmates convicted of drug crimes. Okay, so, well, and then let me be fair. It says also freed by the First Step Act is Joel Francisco, a notorious former leader of the Latin Kings gang, who immediately returned to a life of drugs after his release and is now accused of murder. Okay, so, this is Breitbart, but still, I always have to question when news sources go after President Trump, just simply because they like to go after him for every little thing. However, that doesn't mean he's perfect either. So in looking at this, I have a couple of thoughts. This 240 sex offenders, the reality is that sex offenders, you can be deemed a sex offender for many, many things. And a lot of these cases are cases of people who have been in jail for a very long time. So you may have someone who, 15 years ago was put away for, let's say they were 19 and they were having sex with their 16 or 17-year-old girlfriend or boyfriend. Okay. Now, I'm not making any comments on whether that's right or not. What I'm saying is that as times change, some of the standards have changed as well. And there are people who are in jail that really might be put in jail and are there for so long that they see people who come through that have done the same crimes or been convicted of the same crimes they've been convicted of, yet they have much shorter sentences. So on the 240 sex offenders, there are a lot of questions for me in regard to what that means, because sex offenders is a very large term legally. Nearly 60 convicted murders and assailants. So again, is this a question? Because the cases that I knew of in regard to the First Step Act are people who had been, in prison for a very long time. So I'd want to know more about that as well. And then as well as almost 1,000 inmates convicted of drug crimes. So again, what kind of drug crimes were they? I mean, are we talking possession? Are we talking, are we talking marijuana that is legal now in a lot of places where it wasn't, just a few years ago? So I would want to question these things. But on the other hand, I will also say that's, very possible that when you have a program like this, First Step Act, it's very possible that it's not going to be perfect, right? So it might get it right 95% of the time, but 5% of the time, there's a mistake, or someone who seems to fit into the criteria really wasn't a good option. Now, having said that, I also have to look at who is enforcing. So yes, President Trump signed this First Step Act into law, but then it's got to be enforced, and it's got to be carried out by someone. So what is that criteria? How does that happen? And who's the one that is, or, the ones that are making those choices? So again, just some questions I have, and to be fair, I could go through this whole article and do the same thing, right? I could go through this whole article and really question, are they really saying that an individual that is charged with a home burglary could go back into the victim's home? They might very well be, right? What does it look like to give witness names, especially if the witnesses are underage, right? So a couple of these crimes that the article refers to are specifically regarding children. Now, not saying that the children who are in, really it's child porn, in the child porn might be the ones who are reporting these things, but are witnesses. But it wouldn't be unheard of to have someone who is into that kind of thing have a child watch that with them or be involved in that in some way. So a child could be the witness. So anyway, there are some questions here, but there's just a lot of craziness coming out of New York right now, and I thought I would share. So thank you very much. I will see you soon. Bye-bye.